Hey guys, welcome to this episode that we're doing today. Today I wanted to talk about a few interesting topics, but before I get into it, my friend Christian has a website where he sells computer parts and builds. Any product you buy from his website with the promo code NIK will give you a $25 discount on your purchase. And we'll be supporting a friend who's doing an entrepreneurship venture during this time instead of sitting at home doing nothing. So with that, our friend Mustafa has a small legal disclaimer for our topic today.
So for our topic today, we're not providing any legal advice. We're not suggesting that you use certain medicine or not use certain medicine. We duly encourage you to do your legal research on your part as well. So again, we're not legal professionals. We are not providing any quote-unquote legal advice. We're, with the best of our knowledge, we're just providing certain definitions.
Yeah, and I'm also not a medical professional as well. Don't be like, oh, Nick told me this, so I'm going to go do this.
Yeah, so disclaimer here, we're not experts.
Yeah, this is based off of our research from the span of when we came out with the topic. We're not actual researchers in the field.
Yeah.
So yeah, I actually want to talk about complementary and alternative medicines today.
Mm-hmm.
This fucking guy responds now. All right. Complementary and alternative medicines. So one thing that people have to, like, I'm going to give out a few definitions. I'll put the link to this as well. From the cancer.gov website, the main definitions are like the parts of CAM, which is complementary and alternative medicine, which is basically not a part of standard medical care. Standard medical care is someone who is medicine given by someone who has an MD, who is a medical doctor, or a doctor of osteopathy. And it is also practiced by other health professionals such as physical therapists, physician assistants, psychiatric, and registered nurses. It's also called biomedicine or allopathic medicines, Western, mainstream, or orthodox, or just regular medicine.
Mm-hmm.
Anything outside of this is considered CAM, or complementary or alternative. So complementary medicine is the treatment that is used alongside standard medicine, but is not considered to be a standard treatment. So, like example, acupuncture and so on. Alternative medicine is treatment that is used instead of standard treatments. One example is a special kind of diet to treat cancer instead of anti-cancer drugs that are prescribed by an oncologist. Then you have integrative medicine. It's a total approach medical care that combines standard medicine with CAM practices and has been shown to be safe and effective. Mind you, this is from the cancer.gov website. I'll be putting this link down. So basically, in CAM, there's a few branches. So you have your traditional standard medicine.
Yeah.
So this is stuff like Ayurveda, acupuncture, homeopathy, naturopathy, and Oriental medicine, as it's called, Chinese or Oriental medicine. Then you have stuff like massage therapy, yoga, tai chi, chiropractic, or osteopathic medicines. So like they do have their benefits, but the practitioners are not MDs per se. Mm-hmm. Then you have diet or herb-based, like herbal medicines, dietary supplements, and so on. You have external energies as well. So you have Reiki, Qigong, and electromagnetic therapy, and then mind-based. So you have hypnosis, meditation, biofeedback, and so on. Some stuff like census-based work, like visualization or guided imagery, dance, and music also falls under this. So the reason why I'm talking about this is there's both positives and negatives to this field of medicine. So some of the pros that are written by Everyday Health is that it's a wholesome treatment with personalized attention, but and it focuses more on the prevention of the disease than focusing on a cure.
Yeah.
But the thing is, with this, because you're not from a licensed board, like having an MD or so on, there's limited scientific research on it. And because it doesn't have the same scientific research, the marketing is not the same as um, Western medicine per se. And sometimes it can even have potentially dangerous interactions. You don't know the side effects of this per you because of the lack of scientific research that may be present or so on. That the equivalent over-the-counter medication has, like let's say the use of marijuana, for example. It's still prescribed in jiu-jitsu community. It's prescribed in with the reduction of anxiety and so on, but it's not over the counter, or at least not in most places. So it might not provide the same output to you as anxiety medications would. So that's just some brief introduction. Another thing I want to talk about today, which I found quite disgusting actually to come out. I'll put articles to this. It's basically something called seed faith, which is a branch of this, which if you actually hear about it, it'll make your stomach like turn inside out. It's basically where the idea of it is basically if you sow a seed from your need and you pray during that time, you will get the divine power will give you harvest for that. Basically now it's with all these televangelists and so on, it's a monetary seed. You send them $100, they will conduct a prayer to benefit you. Now, faith-based healing and all that has even lower scientific research, and taking money from a person who has a disease who is already struggling to pay for his medical fees that is based off of research, you taking his money for the seed faith is kind of disgusting in my opinion. And we have Mustafa here today just to give us a brief bit of legal background on what I've just discussed.
Well, thank you, Nick. It's not so much of a legal background, but what does the law say? And concerning the law, we're only going to be talking about Canadian law specifically. We're not familiar with the U.S. Jurisdiction. We're not familiar with the jurisdiction of Europe, South America, in any Asian country. We're sticking specifically with Canada and more specifically Ontario. So in Ontario, I have some documents that are in front of me. That is, so the law and codes that practice and govern the advertising of medical products are the FDA, which is the Food and Drugs Act, and the Controlled Drugs and Substances Act, which is the CDSA. There's also regulations within those acts called like Food and Drug Regulations, or the FDR, and Natural Health Products Regulations. And then there's also like narcotic control regulations. So there's a lot of different, acts and regulations and legislation that covers medicine, that is. One thing that I did want to bring up, that the FDA prohibits the advertising to the general public of any drug as a treatment or cure of a disease listed in Schedule A of the Act, which includes disease considered to be sufficiently serious to warrant this prohibition, such as cancer, diabetes, and hypertension. So like what I just said was a lot of legal jargon, but mainly you cannot advertise a drug claiming to like have cures for something like cancer or diabetes. So you cannot, even for drugs like Viagra, for example, you cannot advertise its use, that is, like what the effects are, but you can advertise that this is a drug, but not the fact that, you know, what's it used for example, because there are very strict regulations in regards to advertising. Now, there was an article back in 2014 by CBC, which the title of the article is Prescription Drug Ad Law Notable for Lack of Teeth, that is, which is to say that, you know, basically the Canadian government has failed to enforce its law banning or advertising prescription drugs, that is, or has failed to put like enough regulations to, you know, limit the advertising of such drugs. And what you might call, which there's also like harmful use of prescription drugs is one of the most common reasons, like why there are a lot of like side effects, because keep in mind, like medicine itself, like it's like, I'm not an expert, but like in terms of the legal framework, as much as there are a lot of regulations, then there are a lot of hefty fines. At this moment, I could not find like a specific idea of the fines, but I would encourage you to look into the FDA, the acts that we'll post the links for, and also
Yeah,
Health
all
Canada.
stuff will be in the description.
We will post also the Health Canada link in the description. Usually Health Canada will have most of the answers for you. And also I wanted to bring out the Sale of Goods Act as well, so which also covers you know, medicine, that is. Just give me a second. I'm just gonna open this page up. All right. So then there's also like Regulated Health Professions Act. So it kind of like overlaps. Essentially, there's a lot of overlap, but the main idea is the Food and Drugs Act. Specifically, you know, you also cannot, there's other diseases over here that, like such as cancer, other than cancer, obesity, anxiety, asthma, depression, appendicitis, I apologize, and other sexually transmitted disease. You cannot post advertising for drugs that claim to cure these diseases, and there is very strict regulations in regards to like very strict like consequences for, you know, advertising the sale of such drugs. Doesn't mean that there haven't been cases that happened. One of the most famous cases in the past, Nick, have you heard of the case called the Carbonic smoke bomb?
Yeah, I've heard of the name, but I haven't heard the specifics of it.
Okay, so a Carbonic, it's a very old case, Carbonic smoke ball. So I just remembered this, to be honest with you. So it's called Carlyle v. Carbolic smoke ball. We'll post the description of this below. And keep in mind, this is a case from 1892, and this was decided in the Court of Appeal. So it's a contract law, like basically contract law also covers, you know, advertising, for example. So what happened was that there was a smoke ball which claimed to cure influenza. There's something like, it's a product that claimed to cure influenza. Now, apparently, Miss Louisa Elizabeth Carlyle, she saw the advertisement, and I'm reading this from the case. She saw the advertisement, bought one of the balls, and used it 3 times daily for nearly 2 months until she contracted the flu. Then she claimed, and keep in mind, the smoke ball company did claim that a £100 reward will be paid by the Carbolic smoke ball company to anyone who contracts the increasing epidemic influenza colds. Like if, for example, if your problems get worse, we give you, it's sort of like a money back guarantee, for example. Now, instead, her problem got worse in hindsight. So what happened was that there was a lawsuit. The Carlyle Smokeball Company claimed that, hey, it was just fluff. Like, you know, in advertising, there is like some leeway for like fluff. And keep in mind, we also use a lot of British cases too within Canadian legislation, because, you know, this has influenced our legislation. So basically, they said that this was all fluff, like, you know, with advertising, how they exaggerate, you know, certain effects of something, right? Like even cigarettes making you a better man, like that kind of.
So basically, puffery.
It was a puffery.
Yeah.
So they claimed that, oh, hey, this is just puffery, that is. However, what they stated was when they guaranteed a money back, if it did not cure, then the judges ruled in favor of the customer, saying that, no, this was not just fluff. You actually boldly claimed that, you know, this thing cured influenza, and it did not. So the Carlyle Smokeball Company was forced to pay, the fine plus damages. That is, they were forced to pay damages. So, you know, this was one of the main, like, one of the foundations of, like, in terms of like advertising, contract law, and like kind of like false medicine, that kind of advertising medicine as well. So it kind of like sets the tone. And then there were multiple cases after that took place that, took, a lot of lawmakers have taken influence from this. And keep in mind that there's a lot of different provinces will have varying legislation, that is. So I think that is what I had in mind. Do you have any questions, Nick? I apologize if I'm not super informative, because like this was a case that just clicked into my mind.
Yeah, so far I don't have any questions. It's pretty clear that some companies might claim puffery. But in the field of medical sciences, it's such a complex thing that, like if you're having a computer, having like puffery there, I totally understand. But the medical sciences themselves are totally different than other products. You're putting it inside of you.
Yeah.
So any form of puffery, even like with electronics, like if you have puffery, like it's not going to cause you too much harm. But like with medicines, it might.
It
so
might.
like that's the only issue.
Yeah, and that's puffery. And a lot of, you see, like, you know, it is an example of puffery. For example, if, you know, there's certain like Tai Chi instructors, or like, you know, there's advertising for like, you know, I don't know, there was something on WhatsApp, that is, Nick, like there were people were even advertising cure for the current pandemic that we have, that is. They were advertising that cure. Do you recall any of the advertising?
Oh, wasn't it like drink ginger water with turmeric in it?
Yes, drink ginger water and it'll cure your those symptoms, blah blah blah, that is.
Yo, I'm making ginger beer. I'm gonna get hammered on it to see if it'll cure any corona.
But keep in mind, like, it's not like, because we haven't even developed a vaccine yet, right? So it's like, why are you advertising a cure for something that has no available cure yet? That is.
Yeah.
Also, YouTube overlords, I apologize for mentioning the word corona.
Yeah, no, we were talking about the beer, not the virus.
Oh, yeah, of course. We're talking about the beer. But yeah, it's like there's just I know for a fact that FDA has received a some criticism, but I do see that the arm of FDA is pretty it's pretty with the Food and Drugs Act. It's pretty strict, at least within the Canadian legislation so far. Another thing I wanted to bring up is there's a concept in law that we study called junk science or novel science, right? And there have been cases, I don't remember them on the top of my head, that, there's, if evidence is presented from something that's very recently scientific or hasn't had enough research, for example, like if evidence is submitted, the judges or judge is very hesitant to accept that evidence and very likely will not accept that evidence because this is not proven science. And he would definitely need like a medical expert or, to verify that if this science is, legitimate, especially in terms of cures or in terms of causing certain diseases. So usually a lot of them are willing to call out something that's a crock of insert SHIT right here, a crock of SHIT, because there have been scenarios where that has been used as sort of like evidence to support one's case. But there is an example. I know it's not related to medicine, but it's related to psychology and sociology, that is, because sociology is also a science that does tie into it. A very recent case I was reading about was the teardrop tattoo case. In Scarborough, there was someone who claimed that, and this, I remember, I just wrote a paper. I wrote a paper like last semester. But yeah, so someone claimed that a teardrop tattoo was indicative of a gang member killing someone of an opposing gang member. That was the claim, that is. And this sociologist, whatever his field was, he claimed to have done multiple interviews and said that that way a particular gang member was convicted. However, that gang member appealed the decision, and when the court really examined the science, there were several flaws because, there were no outliers in his statistics. There have to be certain outliers, right, in statistics. And a lot of records, his so-called video records, were destroyed or not available. So that also cast a lot of doubts. Also, his sample size frequently reduced significantly when they closely examined that. I'll also find the case and put that in the link below. I apologize if I don't remember the case name itself, but I think this was a result of, and again, it's funny, like medicine, science just tie in with the gang war too. It ties in with the gang war. Like there's just so many aspects of it and the legal system as well. So I know I'm not making a lot of sense, but basically it was debunked that a teardrop tattoo meant that a gang member killed an opposing or fellow gang member, or a death of a fellow gang member, because he claimed the three things: the death of a fellow gang member, killing an opposing gang member, or death of a family member. However, the sample size only included those who killed rival gang members, that is. So that was how his research was practically debunked. So giving that, like, the proof to point is the fact that your evidence if you present like any form of medical evidence, or if you claim something, you will have to back it up with research. You make any medical claim or any medicinal claim, you have to back it up, because the Crown, once they will poke their finger and look at the evidence and hire some experts, and they will verify. So eventually it will be discovered that whatever you say is either true or false. So do you have any questions? I saw I went on a rant.
No worries. People come in to listen to your rants. But yeah, with that, I want to go into more of the depth of, I understand that there's rules on what you can present for the
For evidence, as evidence,
as evidence.
or like if you claim that something is a cure, that is, if you advertise it as a cure, if you're caught by the legal system, you better have some evidence to back it up. That is.
Yeah, but what would the procedures be? Like, let's say you don't, or you did do your research, or the research that was presented at that time does feel right to you, or your cultural background and so on. What would the effects of like, what's at this point, like, what's the procedure for denying the scientific and like medical basis and going towards alternative medicine
Yeah.
as
Now
a
keep
cure?
in mind, like alternative medicine already has kind of like a disadvantage, that is, because they will be ruthlessly cross-examined. Because in the court, right, when there's a procedure that's happening, the attorneys and the counsel will cross-examine your evidence, that is. So when they cross-examine, and if they find like any flaws in the study, or what the patients said, or even like just the patient feeling good would not be enough. That is, a patient feeling good would not be enough. It's more like, is it actually having an effect on said patient, that is, and what are the effects? And, you can, and there's just like, you just have to, there's no like set, clear definition of it, because science itself is ever changing, right? And science is also open to, inquiries and new discoveries and blah, blah, blah. But when it comes to alternative medicine, it's like, they will scrutinize it heavily, in at least legally speaking.
Yeah, because I still remember the day in science, it was, or like doctors were injecting heroin into their patients.
Mm-hmm.
But even then, with our current knowledge, but like back when they were doing it, they were still using corn stalks to clean their ass. But in our current day, we have a lot more knowledge about the medical sciences.
Yes.
To a point where like CRISPR were able to create genomes and so on. Like, I'm being really superficial here, but like our knowledge has increased exponentially.
Yeah.
Since back in the day, especially since the last epidemic of influenza.
Yeah.
Or the flu. But my main thing would be, what would the basis be for refusing certain treatment? Because I know I know you have a case about Jehovah's Witnesses who refuse any treatment with blood transfusions, and they would say on behalf of their family members as well, right? So what would the case be for
that's
treating
again,
mandatory?
It's a good question, actually. Like, what would be the grounds of refusing proper medical treatment? And one of the main things is it's only common law. It's not like statutory. That is, because keep in mind, how the legal system works is there's statutes, like I mentioned earlier, like the FDA, those drug acts, that is, that I already mentioned. But then there's something called common law, which has been a result of past cases, that is. So in common law, religion can be a grounds for refusing certain type of medicine, that is, especially in the example of Jehovah's Witnesses. Actually, let me just read the case for you. This is a very famous case, actually, for our viewers. This is called, okay, where did you go?
Because, yeah, like, some of the stories I've heard are extremely sad. Like, I'm not going to scrutinize anyone for following a certain belief. But I gotta wonder, like, what makes them believe that, like, tells them to stop, or tell a doctor to stop treating their child when their child's about to die or something like that. Like, it just makes me really sad and wonder what, like, the procedure would be for dealing with someone like that.
Yeah, for transfusion. So there have been, like, recent... blood transfusion. Just give me Give me a sec. I swear I did have the case. There we go. Millet v. Shulman. Okay. So this is a famous case from 1990 specifically. And the topics that are covered are blood transfusion, assault, battery, and consent to treatment. And also, so I'll give you a background on this case specifically. So this started with Ms. Shulman. Actually, what's the name? Millet v. Shulman. I think it's the name. Okay, so feel like there's no name. Where is the name? Okay, so Dr. Shulman, and then there's Millet, who was the patient, that is, who was a Jehovah's Witness. So she was carrying a card saying that no blood transfusion as member of a Jehovah's Witness. So the physician at the time, Dr. Shulman, he, he refused, he refused to acknowledge that declaration, even though he really wanted to save the victim's life. The victim was part of an accident, a very terrible accident. So when he did so, it caused the victim, the patient, that is, mental distress, and they had to award the Jehovah's Witness member, Millet, $20,000 for mental distress. Can you believe that? $20,000.
Are you sure it wasn't CTE from the accident? Are you sure this wasn't head trauma caused by the accident?
No, this was, let me just see here. It's taken unconscious, examined by the defendant's physician. In the emergency, he concluded that a blood transfusion was indicated, but a nurse discovered a card in the plaintiff's purse, identifying her as a Jehovah's Witness, and requests on the basis of religious convictions. She was given no blood transfusion under any circumstances. Physician probably administered transfusion. Okay. So yeah, in this case, however someone's opinion may be on this accounted for assault and battery. This also accounted for negligence. So in total, now keep in mind, this is an adult saying this, right? This is an adult who already said, so you actually carried out a procedure without their consent. However, there are some exceptions. Again, it's very it doesn't sound fair, but this Millet, when a Jehovah's Witness member carries a card, even in a potentially life-threatening situation, they will, medical professionals are obligated to respect that. However, what the judges or the justice system did say is that the medical facility and the doctor will not be held liable for any, problems that are caused by refusing blood transfusion, like death, any form of disease or anything like that, or any way they could have prevented something. They won't be held liable. It will be on, the onus will be on the, the person or refusing blood transfusion. So it kind of balances things out too. It's okay, you want to refuse blood transfusion, we're not going to be held responsible for this. You chose this path. So if you want to die, go ahead, die. That's what the government and the legislation is saying. Now, when it comes to, I know you and I had a discussion about this earlier. There was something called, what is the case of minor status? Is that what you wanted to ask, status? So, yeah, okay, minors. Minors is a bit tricky. Minors gets a very, very, very tricky. However, I have found some cases, some of them are from Alberta, the Alberta Director of Child and Welfare. There's also child and family enhancement case. There's a bunch of cases I also found this is in 2011. Actually, no, not this one. Okay. So generally speaking, the idea is that if it's a minor, they cannot consent. That's the general idea. All right, actually, where did that case go? I literally, there's just so many of these. I actually how did I lose this case? Okay, so
You need Harvey Specter to win for you.
yeah, transfusion, minor.
And with that, I also have 2 more questions I just wanted to ask.
Sure. Yeah. Ask the questions while I Oh, there it is. Okay.
So yeah, my 2 main questions would be: 1, wouldn't the how would the Hippocratic oath that the medical professionals play into this situation? And 2, what if like in that case they were in a life-threatening situation, but and the doctor refuses to goes in accordance with the ID card, refuses to give a blood transfusion, which ends up causing a lot of harm, but the patient wasn't able to consent to saying, "Oh, scratch the card, give me the transfusion."
Now, keep in mind, if the card says it, if they're carrying, they have to carry the card. So if they're carrying the card, it means that they've already consented to refuse the treatment, that is. So that's kind of like the common law rule, that is.
Yeah.
And, what do you call it? And this is only in regards to adults, that is. If they're sane, I would say usually someone above 16 or 18 is, considered an adult or able to consent, that is. So there have been scenarios where blood transfusion was necessary for an infant, that is. However, the child services was able to intervene and prevent the parents interfering with the matter. So if they're very young, minor, for example, they had just been born, or they're an infant, or they're a child, right? So the services, the health services can intervene, and the parents can still be allowed to, visit the child. However, they're not allowed to, interfere with the medical procedure, despite them being Jehovah's Witnesses, because there are children, that is. They're not of sound mind. You have to be of sound mind to be able to consent. And children are not considered to be of sound mind. So that's the simplest of it. There have been scenarios where, what is a mature child, and which is what's debated, 16 and a half. There have been situations like that where I actually just found something here that, so there have been appeals. Is there an illegal advisory committed? My apologies, because there's just so much information, because this is a very legally gray area, that is. It may not be even,
Yeah, this topic is really
it's
morally.
And you can expand on this so much, and
I know this isn't the topic to be making a joke, but my sick perverted mind has a joke for this.
I mean, if the YouTube overlords don't destroy your channel, then go for it.
I don't know if you heard of this chick called Cassidy Boone.
Mm-hmm. No, I haven't heard of her. What about her?
Oh my God. So back when I was in first year, this was in 2015.
Mm-hmm.
I don't know if the video got taken down or something, because I haven't been able to find it ever since. If I find it, I'm putting it in the description below. Yeah. But this chick basically was she was yo, I'm gonna go diving off this diving board near in a lake or something. While she was jumping off, she hit her head against the backboard and fell into the water and was unconscious.
Ooh.
Some guy jumped into the water, saved her, and did CPR.
Yeah.
Apparently, she sued him for rape. Being he touched me without my consent. I wasn't able to give consent.
Yeah, and technically speaking,
And I'm like, I forgot what I know. It's like the Good Samaritan Act or something, basically being like, if
yeah.
you
There's
save
the
someone's
Samaritan
life,
Act. Yeah, there's the
yeah,
Good
because I'm a
Samaritan.
lifeguard, right? It applies to me. Like, if I go save
Uh,
someone's life while they're like break a leg or like drown in a pool, and like I do proper CPR, but they then try to sue me because I broke their rib or something, like it doesn't
uh,
affect me.
yeah, it only would matter if like there was some damage caused. That is, again, that's on top of my head.
Yeah.
That they could sue for like, they could potentially sue for mental distress too, because it does, cause lack of comfort. But that's where, it gets very gray.
Yeah, and I was thinking like I don't know what side to stand on this debate because
Yeah, it's
she,
I'd rather
it,
not get into this debate. That is,
I'd rather not get into it right
I'd
now because I
rather
don't want
know,
YouTube like,
yeah, and I'd rather know both sides of the story first,
yeah,
like listen to their perspective before I kind of make a judgment. That is,
yeah.
I'm just like looking at this. So yeah, this is the applicant Tyron Hughes was diagnosed with anemia, bone marrow had ceased to. Okay. Yeah, they were refusing, a mother and a child were refusing blood treatment, that is. So, and then they kind of claimed that, this was violating Section 2 of their rights, of Charter of Fundamental Rights, right? They started using the Charter, but this was dismissed basically because I'll actually send you a link to this specific case because this is a very interesting one. I encourage our viewers to read. The appeal was dismissed because of the fact that the child is not a, what do you call it, a mature child, that is, or at least not of sound mind at the age of 13, because there's still like undue influence from a parental figure. There's a lot of undue influence as well. So, when there's a child, like there's there's that you cannot force a child to refuse blood transfusion as a parent. You cannot prevent a child from getting the treatment necessary. That would account for almost borderline child abuse. That is. So any medical procedure that's available, you must get that for your child. So yeah, the legal system does have a sort of like a protection for children, that is. However, when it comes to adults, if they're of sound mind, again, if they're of sound mind, that is, they have consented. If they have the card, the Jehovah's Witnesses card, yeah, they have consented to refuse. Or even if they're unconscious or conscious, they have consented to refuse blood transfusion. You have to respect their wishes, because there's also the charter, because charter has the second section of the charter which says, the right of religion, freedom of expression, and speech, blah blah blah. So that's where it covers, and freedom of thought as well. So that's kind of like my answer. I apologize if this is not as black and white as it presents itself to be, because it's a very dicey situation. My personal opinion is that I would prefer that this was not a rule, like to refuse certain medical treatment, such as a blood transfusion. But at the same time, you kind of want the state to maintain freedom of religion, that is, or freedom of thought and freedom of expression. So you kind of have to like balance things out, that is. So you have to maintain a balance, because, sure, the state does have, permission to infringe on certain rights, that is, because rights are not absolute. We're not like the United States. However, we kind of, we have to also maintain like some form of, we need not to invade in every single thing. So, in my opinion, I feel like, this shouldn't be a rule where they're allowed to refuse blood transfusion, but what can you do, right? And this is only common law. So I wish there was something that codified this, like an act or a regulation that's like released in Parliament, like, bam, let's codify this. Because usually it's only codified when it comes to Parliament, that is, and nobody has raised this issue in Parliament as of yet. I may be wrong. In the comment section, please correct me if this has been raised in Parliament. Yeah, that's kind of my take on this.
But yeah, like I share really similar views to that as well, where you can follow whatever religion you want. You can also take or refuse whatever medical procedures you want that are ambiguous in terms of what results they can provide. But if there's a certain percentage probability of guarantee that of success of that medical procedure, then it should be done, in my opinion. Like with a blood transfusion, like if giving a blood transfusion increases chance of survival by like 75% or something, like we don't know what can happen, like an artery can rip or something like that after the thing, and like the person will die. But by saying like, oh, if I give the blood right now, they will live, 75% chance. Or something like that, some kind of benchmark. I'm not a medical professional. I would have a medical professional give that kind of percentage.
Yeah.
Then I would, the person would waive their rights and just get that treatment. Because I understand, like, if you were to look at the religious perspective of this, it was originally like to say like you can't get transfusions because thou shalt not drink the blood of another man. Yeah. Which is basically stop cannibalism in the Bible, right?
I think in Acts chapter 15 that's mentioned somewhere there.
Yeah. 15, I haven't read, like, this was from my knowledge when I took a poli-sci course.
Yeah.
But so it's been a while since I read this. I forgot it's specifically.
Definitely in the book of Acts, for sure. It's in the book of Acts. I'm guessing this is, New Testament.
Yeah.
I'm guessing this is New Testament, that is.
Yes. Yeah, this was like there's a certain type in certain region where cannibalism was a thing in that region. So this was to stop cannibalism. This has nothing to do with blood transfusion.
Yeah, like
when a pack of it's like the same thing with eating kosher. Back then, people didn't know what trichinosis was. They would just eat raw pigs and everything. But like now we know that you have to cook pork to 135 degrees, or else you'll get a parasite and stuff.
Absolutely.
That's one of the reasons why having dairy mixing having pork now makes a lot more sense than back then.
Halal meat too is in a way like kind of like sort of a method to like sacrifice a meat, that is like get rid of the blood inside the meat and then make it safer. That is it's sort of like procedure, but now we have like modern techniques to do that as well.
Yeah.
So we have advanced.
We definitely had like there has to be a certain point where we got to remember that these texts were written the earliest text was like written like
I think the earliest biblical text that is was written around 500 BCE, 600 BCE, earliest. That's approximately like, I'll even be generous. Okay, let's say even 1000 BCE. Let's be generous. That's 3,000 years old. This is very long. Very, very long.
Yeah, they were banging rocks together like like back that time. Like
they weren't exactly monkeys per se, but they were definitely desert-dwelling individuals. Like they're living in the desert. Imagine
their knowledge of science isn't.
It wasn't limited. Like it was pretty limited actually, because keep in mind, like even like the historical figure. No offense to any religions, that is the historical figure. What we see as Jesus Christ, as mentioned by scholars, he was a man from a village in, what do you call it? What's that village name? Bethlehem. That is Bethlehem and Galilee. He's a man from in Palestine. That is. This is a man in ancient Palestine. Sure, it was under the Romans, but that area was still very underdeveloped. So the founders of this religion, were in a way kind of like, I'm not no insult to like Jesus, the historical figure, because he didn't write the books. It was Paul. Like Paul was the Syrian. But when they wrote these books, they didn't have they had a very limited knowledge of science, that is. So and they kind of wrote it from a theological perspective. To keep in mind, this is all a theology, that is. It's not hardcore science. Like I've seen people claim like scientific miracles in the Quran, scientific miracles in the Bible, and I'm like, no, this is a theology. This is the same book that's saying the sun rises and falls. The sun doesn't actually rise, for example. It's the earth rotating around. So you can count that as a scientific mistake, but because it's more of a theological perspective, so we cannot take this text in a literal sense.
Yeah, like there's a lot of stuff that, yeah, we can credit to it,
Mm-hmm.
like art and so on.
Art, human rights, and all that stuff, right?
But like, it's just to the point where like Moses was basically a guy the burning bush. They did research in the University of Tel Aviv where like it's basically, I forgot the specific name of the bush, but it's a leaf that's filled with psychedelics, right?
Mm-hmm. Yes.
I sound like Joe Rogan right now, but Moses basically saw God after he took psychedelics, but the Torah is forbidden against drugs.
Yeah.
So the founder of that religion, or like the guy who wrote the Old Testament, was high on drugs, but he
supposedly. Keep in mind, he supposedly wrote this text. Because keep in mind, like, there are 5 books of Moses, which is Torah is 5 books, right? And also keep in mind that a lot of stories about even Moses himself are legends. Like, the baby going into the river Nile and avoiding the crocodiles and whatnot and reaching the kingdom, that is, the Pharaoh's kingdom. That story was ripped off from an Akkadian legend of Zargon. So Zargon, the Akkadian king, had the same exact legend. So
Akkadian means Scotland,
it's the
right?
ancient Iraqi Babylonian for that area, like ancient Iraq, that is.
All right.
Very ancient, 3,000 to 5,000 BCE. Like, this is old. So there were tablets that actually describe the exact same legend. However, this is another person who has a completely different story. So, so you cannot like pinpoint exactly like how legitimate, because like the legitimacy of the Old Testament, the New Testament, the Quran, any holy book can be challenged and debunked pretty easy if we're looking at it from a strictly like scientific point of view. However, or historical point of view. However, if you look at it from a theological perspective and mythology, then yeah, it's just mythology. That is. Yeah. So, you cannot take these books too seriously. And I believe a lot of individuals are smart enough, even religious people are smart enough to realize that, yeah, this is not realistic.
Yeah, like there's a reason why I don't follow it as much. Like, everyone's born a sinner, yet I have to go to that place and listen to some guy who touches kids and give him money every week.
Oh, yeah. Like the amount of child abuse that is prevalent within religious like priests and monks and fucking I apologize. Oops, I said the F word. Amongst like these, I apologize, but like I have sinned. Oh, YouTube overlords, I have sinned. But yeah, like the amount of abuse that goes on within religions. Oh, especially Jehovah's Witnesses. I think there was a case in Australia about like certain child abuses that were reported within even Jehovah's Witnesses as well. Well, again, keep in mind, this is the Australian jurisdiction, so I don't have a lot of knowledge about the Australian jurisdiction and how they deal with certain cases. So, I'll send, I'll actually find a link to that as well. Like, A YouTuber called Theremin Trees. He covers that topic about like the child abuse and the religion itself. So a great, also someone to check out as well. I highly recommend. But yeah, we'll provide certain links to whatever we've discussed, basically.
Yeah. So everything that we discussed will be in the description. Thank you guys for tuning into this episode. And I actually got a fan response for
Oh wow, already?
today. No, not for this podcast, but for the previous episodes and so on. Someone really liked my content and felt like they were inspired. So yeah, like, thank you for your support. Without your support, I wouldn't be able to make what I do. So yeah, please do give me any feedback that you want to see, any topics you want to see. Please do subscribe. Please do spread the word. Without you guys, the audience's support, I can't make any more content, because this is, if I wanted to have discussions, like, all the people I have on are friends. So like, I can have a discussion with them on my own.
Yeah.
This is for I want my discussions with my friends to benefit people.
Yeah, absolutely.
So yeah, please do like and subscribe. And before we leave, I know the fight night's coming up with the title card being someone that is really like prominent. So I don't know if you know Tyron Woodley.
Tyron Woodley. Is this the same man who came in that movie Sultan, where he had a fight scene with Salman Khan? Is this the same man as you're speaking?
Yep.
Tyron Woodley. His picture's not coming there.
Yeah, 1 second. I'm going to search. Tyron Woodley. It's this guy.
It is that same man.
Yeah.
It is. I actually really enjoyed that fight scene he had with like Salman Khan. That is. We'll also post a link to that as well.
Yeah, and like most people got to realize Salman Khan was huge in that movie, and this guy like looked bigger, just as big as, if not bigger.
Bigger, yeah, slightly bigger. I even remember like what do you call it? An Akshay Kumar movie which had The Undertaker in it too, and Akshay Kumar looked like a dwarf in front of The Undertaker. And like Undertaker, keep in mind, Undertaker's like 6'8", 6'9". Tyron Woodley's only 5'9" and 170 pounds. So keep in mind, Salman Khan's about 5'7", 5'8". Relatively jacked too, with low body fat percentage. So he could be around the same weight category as well. But yeah, no, these are some interesting stats that you've pulled out here. So Tyron Woodley has 19 wins, 4 losses, 1 no result. And Gilbert Burns, on the other hand, has 18 wins, 3 losses, and 0 no results. Okay, so United States, Brazil. Only
one thing that shocks me is at 5'9", 74.
He has a pretty good reach. Keep in mind, he has longer arms too, right? So you have to also take in mind the long arms. And he has longer legs too, because he does have a very good leg reach as well.
Yeah, so, and he's also a wrestler, so having the extra length in the limbs would probably be to his advantage.
Oh yeah, keep in mind, like if he's a ground and pound grappling, like that would be pretty. It looks like it could be in his favor, because in terms of weight, he has the advantage because he's slightly shorter, but he's also heavier, which kind of like you can go under. It gives you an advantage in grappling, at least. So Gilbert Burns will have a tough match. Sure, but Gilbert Burns himself is not, he's pretty seasoned, he's pretty experienced as well. So his experience could help him out.
Yeah, like the thing is, with the smaller weight though, like the 15 pounds difference, I mean, Gilbert, like, is going to have a hard time defending Tyron's Because at that size, at this weight, definitely Tyrone has the strength advantage. That having a wrestling background,
Mm-hmm.
and that to being the #1 welterweight right now.
Yeah.
My man Burns is gonna have super tough time defending.
But we're still
any
like
takedowns.
we'll still cheer for Burns and Woodley. Both guys are amazing fighters. We're still cheering for both of them.
Yeah.
And let's see the win percentage that is. Like, okay. So Tyrone definitely TKO advantage, but submissions, surprisingly, Gilbert Burns has won more by submission. So, you know, he could be a surprising grappler on his own. And by decision, that is, Tyron Woodley has won more by decision, surprisingly. Now let's look at the average fight time. So roughly more than 2 rounds, both guys can go because they have decent stamina. And they can go more than 2 rounds because 5 minutes more, like 10 minutes is like 2 rounds. And this is more of an average, that is. So they've probably gone longer.
Yeah.
And you were saying average knockdown per 15 minutes. Tyrone seems to have a higher knockdown per 15 minutes as well. So Tyrone has some pretty good stats in comparison.
Yeah, like in my opinion, like this guy is a huge athlete. Like this is their striking percentage. Obviously, Tyrone's is going to be a lot less compared to his
Gilbert
grappling.
lands more strikes in comparison, but however, the significant strikes, Tyron Woodley has a higher percentage.
There's almost the same, but like for someone who's not a striker, Woodley surprises me.
Yeah,
that he's able to go on par with Burns.
Now keep in mind this is past match statistics too, so things can change. Anything can happen. So in a fight, how well prepared you are is also going to be taken into account, which you cannot reflect in statistics. But as far as statistics go, I would put my money on Tyron Woodley. That is.
Yeah, and the takedown.
Interesting. Gilbert Burns has a slightly higher average of takedowns when it comes to grappling.
Yeah, but like the defensive ability because of that.
92%. Good defense. Very good defense. And, you know, submission average. Gilbert has had more submissions, sure. Oh, yeah. He has significantly more submissions.
Yeah.
So this fight, Gilbert can surprise us with his grappling.
Yeah, it was a really good match in my opinion. And did you watch the Ferguson versus Gaethje match?
I saw the results, that is, and I heard Ferguson lost, that is.
Yeah, and Ferguson took punishment like a man. Like this guy said his orbital, I think it was in like the 2nd or 3rd round, his orbital bone broke.
No.
The orbital is like right here with punch, and he still fought like a man. And Herb Dean had to like stop the match.
I recall like Ferguson did have the capacity to take a lot of punishment too. That's what we discussed as well.
Yeah, but like he's a living, walking CTE machine at that point.
True. Which is also like kind of like which concerns me about his health too. His health is a huge concern as well. So yeah, that's you know, I apologize if I haven't watched the fight because you know, we haven't had I have gotten lazy personally speaking too, like with coursework and stuff. So you know, and also with the current pandemic, it's kind of like you're trying to keep yourself occupied with different things, you know. So
well, all right, guys. Thank you for tuning in.
Thank you, guys.
Thumbs up, subscribe,
and like and share.